Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. Meet Travis Shoemaker, a man once given the grace of probation for injuring a child, but instead of rehabilitation he vanished. Twice. Across state lines. Probation violations, 9 counts, new crimes in California, domestic violence and false imprisonment. The courtroom's done waiting. But here's the twist. Shoemaker claims it was all for medical treatment. Was this an act of desperation or manipulation? Then comes Domingo, fresh out of prison, caught with a gun, accused of barricading himself in a house with a child. 3 men. 3 different paths, but one judge who's not having it. Let's get into it.
Committing the new offense of domestic violence and false imprisonment in 2023 in San Francisco County, California. Has everyone had an opportunity to review that updated pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections, Ms. Holmes?
None from the defense, Your Honor.
Mr. Hoffpower?
Not for the state, Your Honor.
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. Shoemaker pled true to 8 out of 9 probation violations, and we're not talking minor infractions. He skipped reporting, dodged treatment, and picked up new criminal charges in another state. That's not just a probation slip-up, that's a probation collapse. And yet, the defense is asking for another chance. Why? Because of alleged mental health concerns and a need for more treatment. But here's the kicker. Mental health services were already part of his original supervision plan. So the real question is, how many lifelines does the system throw before it cuts the cord?
It's locally, and so he decided to go elsewhere, and that's how he ended up in California. I think he does have family out there as well. One of the biggest issues, Judge, in my meetings with Mr. Shoemaker is mental health. It is my understanding that he was extended so that he could participate in some mental health treatment. I do feel that he does need to continue to have some type of mental health treatment. He is asking to be continued on probation so that he can get the appropriate treatment. In addition, maybe the court could
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. You can make this up. After violating probation, fleeing the state twice, and catching new charges, Shoemaker still wants GPS monitoring and permission to continue probation. Oh, and at one point he wanted to go to Hawaii. Yes, Hawaii. Thankfully his attorney gave him the reality check. That SEP's not happening. It's almost as if the courtroom is a revolving door and Shoemaker keeps asking for another spin. But when is accountability supposed to kick in? Would you trust someone with this track record on GPS and a promise to stay local?
I personally told him that's not happening. And he then stated that he is willing to remain in Jefferson County and would seek help or additional aid so that he could have the appropriate housing to remain in Jefferson County, unless he is given some type of approval to travel. But Your Honor, Mr. Shoemaker is asking that the court give him another chance to get his probation back on track and to get the assistance of mental health treatment.
So, and real quick, Mr. Hoffpower, I probably can...
You understand? You want me to...
Well, I just want to make sure, I'm looking back at the original pre-sentence report, and none of these issues are new issues. The mental health issues, any drug, that was all addressed.
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. This is where the judge's patience starts to unravel. The state doesn't mince words. They remind us, loudly, that Shoemaker had all the services and supervision baked into his probation from day one. Mental health? Check. Drug treatment? Check. And still he fled the state not once but twice and was extradited both times. Then he claimed California had better medical treatment, but instead he picked up new violent charges. At this point, it's not just non-compliance, it's a full-blown defiance of the court's authority. What do you think, is Shoemaker gaming the system or genuinely lost?
Yes, Mr. Hoffpower.
Your Honor, and I want to make sure that the court, and I want to take judicial notice of the updated pre-sentence, but it's included in there, is that he's gone to California twice and that has been extradited. He went the first time and was brought back, and in 11/30 of 2023, he was extradited back, and then when
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. This moment hits hard. The judge looks back on every chance she gave Shoemaker, the extensions, the added services, the benefit of the doubt, and then with surgical precision, she dismantles his pattern. You left. You got caught. You said you needed mental health treatment again, and I let you. And now here we are, again. It's not just disappointment in her voice, it's exhaustion. This isn't about a single failure. It's about repeated manipulation, broken promises, and a final reckoning. How many second chances should one person get before it's too late?
I said, okay, and now it's the third time you're saying that after we've had to go get you in California. Is there anything else, Ms. Ruiz, that's not in that updated report that you'd like to add? So, Mr. Shoemaker, anything else, Ms. Holmes?
Yeah.
At this time, I'm going to find that you entered your pleas of true, again, to counts 1 through 6 and 8 and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation and
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. Boom. 5 years. Institutional Division, Texas Department of Corrections. No deals. No probation. Just bars. After years of dodging compliance and ducking accountability, the system finally closes in. Let's be real. Would you feel safe with this man back in your neighborhood after 2 failed probations? Drop your thoughts in the comments. Was 5 years enough?
this back in 2022. When you were initially placed on probation, I'm not sure if I did that back then when we started, but because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that written admonishment I provide you to make sure you understand that law, okay? And once you sign that, we'll get you a copy of the certification, and then you can go back with the bailiff. Thank you, and thank you, Mr. Ruiz. Good morning, sir. You're Terry Rose.
Yes, ma'am.
And in cause number 24, DCCR 1369, Mr. Rose is charged with first-degree felony offensive murder. And Mr. Roundtree, what is the announcement? Mr. Nichols, where are y'all?
Your Honor, I tendered to Mr. Roundtree today in court updated discovery.
Okay.
That had come in. It was pretty voluminous, and we put it on a big thumb drive form and gave that to him today.
Do you anticipate anything else coming?
I do not, Your Honor.
Okay.
And I haven't had a chance to talk to Mr. Nichols. I did briefly go through what he tendered this morning, and there may still be some outstanding discovery, but I can get with him and send him an email what I believe may be missing.
Okay.
But I don't want to represent that to the court.
Sure,
But
until you can have a
just
chance.
based on what I reviewed this morning.
So realistically, for you to go through that, to get some other things involved if you need, what I'd like to do is maybe just a 60-day reset instead of a 30-day. That gives you time to go through everything, make any requests to Mr. Nichols. If there's something you need to go out and try to find, get that. And then I'll review the motion and get what you need to hopefully get a announcement maybe at that next court date.
Sounds good, Your Honor.
Okay.
That's fine with me, Your Honor.
Okay, perfect.
Thank you.
Thank you, Ms. Rose. You can go back with the bailiff. All right, sir, are you Christopher Wade? And will your client waive the formal reading of the indictment?
He does, Your Honor.
Mr. Wade, in cause number 24, DCCR 0264, the state is elected to proceed on count 1 only. It alleges you committed a third-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from December 29th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wade is not competent?
There's none.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 8 years in the Institutional Division of
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. The courtroom flies through this part, but don't be fooled, 8 years is serious time for what many might call a non-violent charge. Here's the thing. Vehicle-based evasion isn't just dangerous, it can escalate into tragedy in seconds. And once you agree to a plea deal like this, you waive most of your rights to appeal. Would you have taken the deal or rolled the dice at trial?
Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read that written admonishment I provide you to see what devices qualify as a firearm. And if you have any questions about how long that lasts or anything about that, you can talk to Mr. Samuel, all right? All right, good luck to you, sir. Thank you, Mr. Samuel.
Thank you. Thank you, Your Honor.
Good morning, sir. Are you Brandon Dodd? And Mr. Dodd, in cause number 24, DCCR 2418, you're charged with the first-degree felony offense of murder, and that is from October 14th of 2024. Your indictment alleges that you were previously convicted of aggravated robbery February 22nd of 2005. And what that means is that if, I'm sorry.
Your
Yes,
Honor.
sir.
The state has also filed a notice of habitual offender. We've alleged an additional felony offense, electronically filed and inserted on Mr. Reynolds
I've got
as
it.
well.
I've got it right here. So in addition, Mr. Dodd, the state has filed the appropriate motion that alleges that there, in addition to that aggravated robbery, you were also convicted of attempted Hobbs Act robbery in the United States Eastern District of Texas, Beaumont Division, October 16th of 2019. What that means is that if you are found guilty in the murder case and those two prior cases are true, then you would be considered a habitual offender, which means your minimum punishment is 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here on the tablet that you've signed with Mr. Reynolds. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 35-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial and are found guilty and what your options are. Do you understand all of that?
Yes, ma'am.
And Mr. Coleman, is there any other information or discovery that you anticipate that you don't have?
No, Your Honor, and for the record, I'd like to point out that that 35-year offer was a today-only offer. The original offer was higher than that.
So I want to make sure you understand, Mr. Dodd, that after today, that 35-year offer will not be accepted by the court. So if you're not guilty, go to trial, that's fine. If you change your mind later and you want to enter a plea of guilty, it would either be to something different than that, or it would be open to the court unless there is some new evidence that Mr. Coleman and Mr. Reynolds weren't aware of today. Do you understand? And do you want to read?
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. Now we get to Brandon Dodd, a murder defendant with not one but two prior felony convictions. He was offered a 35-year plea deal and turned it down. Let that sink in. Because if he goes to trial and gets convicted with those priors on the record, he faces 25 years to life. This is a classic high-stakes gamble. Why reject a deal that offers some light at the end of the tunnel? Does he think he can beat the charge, or is he playing for jury sympathy? What would you do? Take 35 years or risk life?
No, we can make whatever change if there's any issues with regard to offers or negotiations based on that.
Yes, ma'am.
Okay. All right, you can go back with the bailiff. Good morning. Are you Anthony Domingo?
Yes, ma'am.
And Mr. Domingo was previously in court, entered pleas of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon and the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in each of those cases. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We have, Judge. Yes, sir.
Are there any additions or corrections?
Nothing to finish, Judge.
All right, Mr. Lewis, you may proceed.
Judge, with Mr. Domingo, there was a situation, of course, where he had not been out of custody long at the time when he picked up this case, these two cases here. And when he was released from custody from TDC, he had made several strides as far as trying to get stable, as far as maybe finding somewhere to live, stable job, doing what he needs to do. Unfortunately, you know, some of his decisions as far as who he was involved with at the time did not help matters. He also, according to see from the PSI, that there was some drug use that was going on And from talking with him, I think a lot of that was self-medicating from a lot of the things he dealt with while he was in TDC until after. He lost several family members during that time period, and I believe he even came home to family members that was ill and lost them shortly after. And we believe that community supervision would have the structure of things, of vehicles that he would need to be able to address those issues, address any anger issues, that would allow him to not be in this situation again. I think his attitude, which is clear from his additional statement that he gave in regards to how he feels about the situation he's put himself in, as far as wanting to move forward and be productive. I think even probation and their recommendations as far as, allowing the court to know that there are things that are available that could help him to not be in this situation again. And that's what we're asking for, Judge, is that he's given that opportunity. Like I said, in that short time, he did make, a lot of strides. And I believe that going back to TDC at this point would be very counterproductive to his future that he still has out there for him. He's still young. He still, will have a life there afterwards. And he, as well as Mr. Domingo, would like to address the court as well.
Go ahead, sir.
Well, Miss, it's like this. I just got done doing 10 years before, 6 months before I got locked up. And I wasn't doing nothing besides really going to work and taking care of my son and helping my aunt out. That's what I say with trying to get myself together. And basically, Miss, like I just feel like, I don't really deserve no time, like, cause the thing is, like, you gonna do what you wanna do, Miss, but my thing is, like, I'm not a bad person.
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. Anthony Domingo stands there desperate, talking about his son, his job, his future. And you almost feel for him until the facts land like a hammer. He had just finished a 10-year sentence. Within 6 months, he's caught in a home with a firearm, under the influence threatening someone. And that someone was allegedly with his child in the house. Even the judge pauses. The emotional stakes are high, but the danger is undeniable. Is remorse enough to undo the risk, or is this another example of someone blowing their second chance?
Barricaded, you were out of prison. You'd served 10 years.
Yes, ma'am.
You grew up, more mature. You have an opportunity at freedom.
Yes, ma'am.
You say you're not a bad person and you were doing things great, but you got out, you started using drugs again. You barricaded yourself inside a home with a gun with your 11-year-old so that the SWAT team had to come out.
I didn't barricade myself.
But you don't deserve anything. How does that even make sense?
Now, in this situation, it's critical.
It is.
It's very critical.
It's very critical. You're right.
Like, the paperwork from the police report is true, but it's not all true. Because I didn't barricade myself in the house. They could have came in at any time.
Okay, but you were inside the house with a gun. You didn't put something up against the door and barricade
I
it.
did not do that.
Right. Okay, but still, you're inside the house with the gun with your kids. So we're not going to play semantics here and word games about what did and didn't happen. They don't know what they're walking into. They know that they probably received a call.
Saying that somebody had a gun.
Yeah.
And I understand it.
And that part's true, right?
Yes, ma'am.
So they don't know what they're coming up on.
Yes, ma'am.
Mr. Smith?
Judge, the Ring camera that was associated with this also showed that he was brandishing the weapon, threatening to kill the paramour, and he's had, I believe, several chances at probation. He's never been able to successfully complete probation. He was on probation from 2011 until he finally got revoked on the other case in 2014. After that, he went to prison, was in prison for 10 years, and didn't make it 6 months before he committed these crimes. The chances of him actually being able to make probation are very small, I believe, and the fact that this could have been a lot worse had police.
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. The DA drops a bombshell. Domingo was high on a cocktail of drugs, ecstasy, codeine, Xanax, cannabis, and more, while armed inside a house with a child. The police had to send in SWAT. This wasn't a bad day, this was a recipe for tragedy. The DA makes it clear Domingo had every opportunity to succeed after release, and he blew it. Can some people simply not be rehabilitated? Or did the system fail him first?
Cannabis, Xanax, ecstasy, and codeine.
Codeine.
After having just gotten out of prison and possessed a firearm and threatened people with the firearm.
Was there some time when you got out of prison that you had to go to a halfway house?
Go back.
Because you had to do all your time?
I did all my time.
You did every bit of it.
Yes, ma'am.
You know what that tells me?
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice.
I mean, most people make parole.
Not
You
saying
know?
For the most part, I didn't.
You didn't?
I'm not gonna lie.
Okay.
About nothing, man. I was young. Like, going through TEC, it's hard to.
I have no
hard to
idea.
fight
I'm
for
sure
it.
it's hard. I have I mean,
And Judge, if I may,
yeah.
I think some of the things I was talking about as far as the things that's available through probation, Judge, would help with his emotional stability. Because a lot of that was, like I said, the things he dealt with while he was there and what he came home to. Like I said, he made strides and everything as far as to try to get himself.
Charging the devices and set the issue, it sets what it implies. If you go off-grid for even a moment in a case like this, you better believe the court takes notice. In one courtroom, we witnessed the full spectrum of justice, from second chances revoked to deals rejected, and from remorseful pleas to outright defiance. Shoemaker ran out of rope, Wade locked in a deal. Dodd rolled the dice, and Domingo, well, he showed us just how quickly things can spiral after release. This isn't just a docket, it's a warning. The court can offer help, but only you can choose to take it. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns every week. Until next time, stay sharp, stay safe, and stay tuned.
So this shows that you last used alcohol April 23rd of 2024.
Yeah, I got good.
Okay. That you last used marijuana February of 2024. So that was in between when you got out of prison and when you got locked up again. It shows that you last used Xanax March of 2024, which is in between that 6-month time. It shows you last used ecstasy March of 2024, which is in between that time. It shows that you last used codeine in between that time, March of 2024. So it shows that you didn't just get out and have a couple drinks and maybe smoke a little marijuana. You just got out and did all this stuff, and got yourself in this position to completely traumatize your own child. I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. And cause number 24 DCCR 1021, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1022, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. Now, here's something, Mr. Domingo, that I don't normally say. You clearly need some help. I'm not going to say that you don't. If you're going to get your life together, it's up to you to get that help. But let me explain something also. Don't talk over me, because I'm not even sure I want to say what I was about to say if you're not going to be respectful. If you can behave in prison, and I'm not saying this is going to happen, but there are things that can happen potentially where your attorney files something for me to review how you've been, and I consider probating your sentences and getting you back out of prison. But I can assure you of this. If you get to prison and act like you acted for the last 10 years when you were in prison, then you'll be there for the whole 8 years on these. That's going to be your decision. All right? I'm handing you the trial court certification in each case that shows these were agreements that I followed, so you waived your right to appeal. I'm also handing you the written admonishment, regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Obviously, you know that information, but I'm required to read it to you. All right, you can go back with the bailiff.
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be... This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be looking at life, and another is facing a revoked probation that could send him straight to prison. So buckle up, hit that like button early, and let's dive into the drama.
Good morning. Are you Jetson Bell?
Yes, ma'am.
And Mr. Bell, in cause number 25 DCCR 0108, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon, and that is from January 20th of 2024. Your indictment alleges you were previously convicted of possession of a controlled substance and delivery of a controlled substance, a third degree and a second degree, October 22nd of 2007. And after those were final, you were convicted of unlawful possession of a controlled substance, second degree, February 4th of 2009. And what that means is if you go to trial in that case and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum 25 years in prison up to 99 years.
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be... Mr. Bell isn't just facing one charge. He's stacked with 3 serious felonies and with those past convictions. The state's not playing. Habitual offender status bumps his punishment range up to 25 to life. And yet he calmly rejects the plea deal of 25 years. Viewers, what would you do in his shoes? Take the offer or roll the dice on a trial. Let us know in the comments below, because the stakes couldn't be higher. One misstep and he's looking at a life sentence.
That shows that the district attorney's office has offered, if you wanted to enter a plea of guilty, a 25-year term in the institutional division. You have every right to reject that and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. You understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
Mr. Nichols, is there any reason in Mr. Smith's file, any notation why this would be,
No, Your Honor, he has the priors that were listed, plus a federal prior, which is, I think, still under their supervised release for, and he's on parole through 2027. I see no reason these would change.
so I want to make sure you understand, Mr. Bell, that after today, I will not accept this plea agreement. Unless there is anything new that comes up, I will not accept a plea agreement less than this. So it's trial, plea open to a jury.
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be... This is what legal brinkmanship looks like. Judge Boyd warns Mr. Bell that today's plea deal is the last one he'll get. It's trial or nothing from here on out. And let's be clear, judges don't bluff. Once a plea deadline passes, it rarely comes back. This isn't just strategy, it's a high-wire act with zero net, and yet Bell rolls the dice. Was it courage, delusion, or something else entirely?
You will be waiving or giving up any right to appeal. And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 6 years. You would be ordered to pay $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding? And do you also understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization?
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be... Mr. Smith might have evaded arrest, but he's trying to do the right thing now. A 10-year sentence probated down to 6 years and a $1,000 fine seems generous. And when he says he's been sober for a year and has a job waiting for him, you can feel that glimmer of hope. But let's be honest, probation is no walk in the park. One wrong move and those 10 years become very real. What do you think? Should the system trust his turnaround?
Yeah, I've been sober for a year and a half now. I've been got my CDL, but I have a life waiting for me. I've
Good.
been on the right path. I just needed to take care of this.
Sure. So what I'm going to do, Mr. Smith, is reduce your bond to $1,000. I'm going to make that a personal bond, which means you're just going to be released without having to pay any money.
Okay.
But there's a few things that are very important about that.
Okay.
If you don't show for court when you're supposed to, then they're going to come after you for the money,
Yeah, of
number
course,
one.
of course.
The first thing you do when you're released today, if it's early enough in the day, is go straight to probation. You're going to get some paperwork today. They'll tell you where to go so they can start that process to do that pre-sentence report.
Okay.
If it's late in the day, go first thing in the morning.
And
Um,
I'm sorry. I didn't interrupt you.
So if you don't do that, then you run the risk of me not accepting the agreement and things could be worse. If you're arrested for anything between now and when we come back for sentencing, also you run the risk of me not accepting the agreement. And did you have a question?
I was just gonna say, that'll all state like which, I'll be in Beaumont for the probation.
Just, if you're living in Lumberton, talk to the, when you're doing that pre-sentence investigation, talk to the probation officer about where you'll be, and they'll start the paperwork to see about courtesy supervision where you are.
So just depending on when they let me go today, whether I go today or in the morning?
Yes, sir.
Okay.
Yep, if it's before 5, then get over there straight today,
All right.
okay?
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be... The judge offers a personal bond to Mr. Smith, no upfront money, just his promise to appear, but she lays it out clearly, miss court, and things get a whole lot worse. And this is the real kicker, she warns that if he doesn't check in with probation immediately, the whole deal could fall apart. It's a tightrope walk, folks. Can he pull it off? Drop your thoughts below.
Did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up, please. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. East is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous conviction. Sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit.
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be... Mr. East takes a 9-month sentence in state jail, and in exchange, the state drops another charge entirely. That's a textbook plea deal. But what follows is a heavy reminder of how deep the consequences go. He's handed paperwork stating he can no longer own a firearm or even ammunition. It's a lifetime ban. These aren't just convictions, they're permanent life changes. Makes you wonder, is the time served the hardest part?
Felony offense of evading arrest or detention with previous conviction, and that's from March 4th of 2024. The indictment alleges you were previously convicted of evading arrest or detention November 28th of 2012 in Hardin County, Texas. And how do you plead to that charge? And is that prior conviction true? Are you entering your plea of guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Celestine's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of evading arrest or detention with that previous conviction. Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right? Good luck to you, sir. You can go back with the bailiff. Good morning. You're LaCaven Jenkins?
Yes, ma'am.
And Mr. Jenkins is charged in 24 DCCR 1026 with aggravated robbery and 24 DCCR 1027 with fraudulent use or possession of identifying information. What is the announcement?
Judge, he's previously rejected 10 on the aggravated robbery case and 5 on the possession of fraudulent identifying information. That offer has not changed. I visited with him. I've looked at the file. There are co-defendants in the aggravated robbery case. And I think during trial preparation, there may be mitigating or exculpatory evidence that would come out. And therefore, he is requesting a trial.
Okay.
However, Judge, this case originated out of Groves, Texas. And I've got a conflict with going to trial with the Groves police. So I'm going to have to ask that I be replaced on this case. If you want me to file a motion, I can.
No, I didn't realize that. Mr. Nichols?
I don't have an objection to his withdrawal, Your Honor. I understand the conflict, and as far as the offer and everything, I know Mr. Smith has been over it several times, and I don't see why it would change, Your Honor.
So, Mr. Jenkins, because of, you probably already talked to him about that, I'm not sure, but he's not going to be able to represent you just because of where this happened or allegedly happened. And so what I'm going to do is release Mr. Reynolds today. I'm going to appoint an attorney today. We're going to contact them personally, let them know that you're ready to go forward with trial, that someone else has looked at it. Mr. Reynolds, if you will make sure and get everything you've received once we get that new attorney to them as far as discovery goes, if there's any media, especially, obviously the discovery portal stuff they can get, but if you've received any media, then if you'll get that to that attorney, and then they'll be out there very soon, and we'll have one more court date with that attorney, then we'll get it moved to the trial docket.
Yes, ma'am.
Okay, you can go back with the bailiff. All right, are you Victoria Bailey?
Yes, ma'am.
And Ms. Bailey is 25 DCCR 0170 charged with assault on a public servant, and in 25 DCCR 0278 charged with assault of hospital personnel. And Ms. Bailey was evaluated for competency to stand trial by Dr. Gapon. I received that report dated April 22nd of 2025. Dr. Gapon makes the finding in each of these cases that Ms. Bailey is currently not competent to stand trial, and that inpatient treatment for competency restoration is warranted. Is there any other evidence with regard to competency, Mr. Parker?
None, Your Honor.
Mr. Nichols?
No, Your Honor.
Then at this time, based on that report, I am going to find Ms. Bailey.
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be... This is one of the most heartbreaking moments of the docket. Victoria Bailey, charged with assaulting hospital staff and a public servant, is found not competent to stand trial. The judge orders a 120-day hospital stay for mental restoration. But when Bailey softly insists, "I don't need medicine to understand," the entire room feels that emotional weight. It's a raw glimpse into mental health and the criminal justice system. How should we balance accountability with compassion?
278, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from May 17th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 24 DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises from May 17th of 2024. If you're found guilty in that case, the range of punishment would also be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 24, DCCR 1530, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024. In that case, what that means is if you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And then finally, in cause number 21, okay, so we've got an MTRP.
Yes, sir.
Okay, and that one, you're on probation for aggravated assault causing serious bodily injury. Based on the nature of that underlying offense, Mr. Nichols, what's the state's position with going ahead and setting the, I'd rather go forward on the motion, honestly, maybe?
I'm looking at Mr. Smith's offers in the case, and that all seems to line up. I don't see why we wouldn't, Your Honor.
Set it for, obviously would take some time. We could set aside half a day and go forward on the motion. It's just as serious as the other, so just as soon get that taken care of. And then if we still need trials at that point, we can get the rest set for trial. So let's do this. I'd like to go through that motion. On those other 3 cases, before we move to that motion, I do want to go through real quick. I've got plea bargain rejections that you've signed with Mr. Smith. It shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. Looks like to 16-year term in the second-degree felony offenses. And so it looks like the offer would be to dismiss the evading arrest or detention with the use of a vehicle for pleas on the aggravated assault with a deadly weapon and the unlawful carrying, those second degrees, for 16-year terms in those cases. Do you understand? And do you want to reject those offers and have your cases set for trial? All right. Best you can, raise your right hand for me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. Here we go. In cause number 21-36882, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation August 30th of 2021 for the offense of aggravated assault, family violence, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department February 21st, May 25th, June 13th, October 12th, and November 5th of 2023. And is that true or not true?
Not true.
So you reported on those dates?
I had,
I mean, and hold on. Well, Mr. Smith, I want to make sure if some of them are true, I mean, if he wants to plead not true to everything, that's fine, but
Well, I was just thinking, Judge, for purposes of this morning, this plea not true.
no, for purpose, he's under oath, if it's true or it's not true. So if you reported, fine. If you didn't report, fine. We're going to get explanations later.
Okay.
So if what I'm reading out to you is not true, obviously the new offenses we're going to have a hearing on. But these administrative violations, if you didn't report, you didn't report. If you did, you did. All right? So on those dates, is it true or not true that you failed to report?
True.
Okay. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you provided a urine sample on July 3rd of 2023 that tested positive for tetrahydrocannabinol and methamphetamines. And is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service. Is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the BIP or an anger management program. Is that true or not true? I'm sorry?
True.
Count 6 alleges that you're behind in your court-assessed fees as of December 5th of 2023 in the amount of $3,192. And is that true or not true? Count 7 alleges that you committed the new offense of aggravated assault with a deadly weapon May 17th of 2024. And is that true or not true? Count 8 alleges that you committed the new offense of unlawful carrying a weapon on alcohol premises May 17th of 2024. And is that true or not true? count 9 alleges that you committed the offense of evading arrest or detention with the use of a vehicle, May 17th of 2024. And is that true or not true? All right, so I'm going to...
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be, Mr. Randall pleads true to 6 probation violations, and now he's waiting on a full hearing for the rest. He missed court dates, failed drug tests, and didn't do community service. But the biggest bombshell, he's also facing new charges, aggravated assault, unlawful carry, and evading arrest. This isn't just a probation slip-up, it's a full-blown spiral, and with Judge Boyd already scheduling a full hearing, this could turn into a total revocation. Can Randall claw his way back, or is this the end of the line?
Sure.
I'll be able to announce I'll be up to speed with Mr. Coleman and my client.
Okay. All right, so we'll just do one more reset, Mr. Dodd. That way Mr. Burbank can get up to speed on everything, go over everything that he's received evidence-wise with you, and we'll get an announcement at that next court date. All right, so you are Jerry Jenkins. And Mr. Jenkins, there is a new indictment in cause number 25 DCCR 03372. You're charged with aggravated assault with a deadly weapon from March 14th of 2025. And so I'm going to, you have your other cases that are set for trial in June that Mr. Burbank represents you on. We're going to leave those on that court date. I'm going to reset this case to that time as well to give Mr. Burbank some time to get all the information and discovery, visit with the district attorney's office, see if there's any change in anything. Otherwise, we will at least go to trial on the other cases, if not.
And Judge, if I may, as our discussions on that proceed, this is also a second degree enhanced, so we're looking at 2 first-degree punishment ranges.
Okay.
I will be prepared to go to trial on either of them, if the court would allow me to choose just based on some different factors. But I will let Mr. Burbank know well in advance of the pretrial date if we cannot reach a resolution, which one I intend to go on.
Okay, that's good because we're already getting close, so that would mean getting ready pretty quick potentially on this new one, Mr. Burbank. So if you'll get with Ms. Malfino, make sure he has everything,
I'll make sure
if there's any videos or media. Okay, all right, we'll see you back on the pretrial date. Good morning, you're Antoine Dill?
Yes, I'm
And Mr. Dill, you were previously in court and entered pleas of true to counts 1, 2, 3, 4, 5, and 6 in a motion to revoke your unadjudicated probation. On probation for the second-degree felony offense of burglary of a habitation, placed on probation. I think the dates in this updated report are, I must be wrong. It says on May 8th, 2025, he met with the high needs officer for the initial visit. Should that be May 2024?
Yes.
Okay, all right, just want to make sure. So placed on probation back in April of 2024 for that offense. The allegations, failure to report, failure to work, testing positive, that didn't do the theft prevention class, behind in fees, and behind in restitution. There was no agreement, is that correct?
That's correct, Judge.
Mr., and I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
You have, Judge.
Any additions or corrections to that report?
Nothing from the defense, Judge.
Not from the state, other than Ms. Court has anything additional.
Okay.
I would like to hear from.
Thank you, ma'am. Go ahead, Mr. Lewis.
Judge, this situation, from talking with my client as well as members of his family, is definitely one that his substance abuse issue is something that he definitely needs to address. He's willing to, he understands that definitely been in his way as far as definitely trying to complete this probation successfully. I would also like to add to that after speaking with him and with some of his family members that I don't believe he was on any type of mental health or any type of conditions dealing with his probation.
He was
I know it's
high needs.
Because from talking with him, there's definitely some things he has gone through in his past that I think affect him and are triggers for him. And I believe that, if he's able to get that type of help, to help with that, I think that would definitely help with the substance abuse issue. I believe there are vehicles available through community supervision that can address that. He's more than willing to accept that help at this point, understands he needs it. I know it looks like the recommendation in the updated PSI from probation is for ISF. It's something that they would recommend. He's more than willing to comply with that and try to work with that as much as possible. If there is anything.
This courtroom is no stranger to chaos, but today's docket is packed with everything from firearms possession to aggravated assault, identity theft, and even murder. Welcome to one of the most intense days in Judge Boyd's courtroom. We'll see seasoned felons rejecting plea deals, attorneys withdrawing mid-case, emotional defendants pleading for leniency, and one heartbreaking moment where a woman deemed incompetent asks, "Do I need medicine to understand?" In this gripping episode, watch as Judge Boyd delivers swift rulings, brutal reality checks, and no-nonsense decisions. From high-stakes habitual offender warnings to emotional pleas for rehabilitation, each case exposes a different side of the justice system. And trust me, you'll want to stay until the end. One defendant may be... Today's docket was a roller coaster of decisions, dilemmas, and defiance. From Jetson Bell risking life in prison by rejecting a plea deal, to Victoria Bailey confronting her mental health treatment, to multiple defendants walking the line between second chances and incarceration, Judge Boyd's courtroom was nothing short of explosive. We saw heartbreak, hope, and hard truths laid bare, and as always, Judge Boyd delivered clear, firm justice without missing a beat. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll be back with more raw, real justice only here. Until next time.
To me, when you were here before.
Yes, ma'am. And I got out, and the second day I was back on the streets. I did not have a plan for my life outside of just getting free. I met with the ASAP team, and they really gave me a lot of inspiration, a lot of hope, so that I can change my life. Granted, Ms. Cord has done an amazing job as my supervisor, and I apologize to her profusely, but I am not someone who wants to waste away in a jail cell.
Well,
I am someone who wants to...
Here's the thing, Mr. Deal. When I looked back at your original pre-sentence report,
Yes, ma'am.
there wasn't an agreement in that case. It was a cap. And the reason for that cap is because you already have felony criminal history.
Yes, ma'am.
You've already had 2 felony probations that were both revoked.
Yes.
And then I gave you probation again because you stood there and did just what you're doing right now. You saying the words,
Please.
you
give me-
stop.
Yes,
You need to stop because it's not going to get any better.
Yes, ma'am.
Okay?
Yes, ma'am.
By what you can say. I appreciate that you probably would like to do what you're saying,
Yes, ma'am.
but you've been given every opportunity. Probation's worked with you. Again, those felony probation revocations, one was in 19, one was in 2021. It's not like they were a long time ago. You've been given every opportunity on probations now 3 times. 3 times. And she worked with you. When I'm reading through this pre-sentence report, Ms. Core tried to contact you. She tried to
I didn't
reschedule.
have a phone. I was just texting her. I was homeless. I have been homeless a lot of my life.
But that's what probation's for, is to help you. You have to go to probation. You can't keep using those things as an excuse.
Yes, ma'am.
All right, so I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily.
Yes, ma'am.
Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a habitation.
Yes, ma'am.
Going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I need you to sign that with Mr. Lewis. It shows that this was not an agreement, so you do have some limited rights to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. I understand this isn't what you want. Take advantage of it, and when you get out, take advantage of opportunities in the community, because there are some that can help you.
Thank you.
All right? You
And
go
I
back
wanna
with
say one last thing to you, Judge. I will change my life.
I hope so,
I
for
will.
you.
For me.
Yeah, I hope so. I really
Yes, ma'am.
truly do.
Yes,
All right, sign that document, please, sir.